No, you don't. You're good. Hey, everybody. Welcome to week bajillion something or other. Gary's going to be upset with me again for saying that, and I probably should have researched which week it was ahead of time so that I won't get chastised when Gary returns next week. Because contrary to popular belief, he actually listens to these and then afterwards gives Jack and I like show notes. You had too many you know, I didn't like the camera angle. No, I'm kidding. He doesn't actually do that, but he does actually listen to them and says, "Hey, just so you know, it was episode, blah 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 blah." So, anyway, happy to be here with you guys today, and it is just Jack and I. As you will see when Jack starts to speak, Jack is on the road. He's going to give out Starbucks gift cards to whoever can guess what Jack's road snack currently is. It's not Cheetos. That would be me if it was, which is great because like it's a yummy road snack, but at the same time, the cheesy fingers do create a little bit of a problem. So we're going to be talking about today some of the legal stuff that we all need to be aware of based on some changes that have been coming out lately. Changes that have been long standing that I think as a business owner, if you're Adam, you are putting your head in the sand and really hoping that it all just goes away. But unfortunately, some of these items have not gone away, and we need to be aware of them rolling into next year. So Jack's gonna give us a good current state of affairs on several things. If you got anything on your mind, as always, hit us up in the chat or the Q&A, and we'll get your questions answered, even if it's off topic, as long as it's, not crazy or a stupid question. We don't answer stupid. I'm just kidding. There's no such thing as a stupid question. But anyway, that Jack's going to go through some key items and current events. But, to go back to relevant of like how close this is hitting home, my son just moved to New York City, and he's a freelance filmmaker. So he, at my suggestion, started his own company. And now he's getting all these, you're going to go to jail and die if you don't do your FinCEN certification. So now I'm getting this panic, Jacob Boatsman. Oh my God, I'm going to go to jail and die. What a strap it. And these are very deceptive advertisements. It's like, you will go to jail and die, pay this fee. And I'm like, God, how is this legal? And he, it's not just Jacob. We're getting these from clients saying, hey, do I really need to do this? Da 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 da. So it's the real deal. So with that in mind, not a lot in current events, I think if you happen to watch the town hall with Kamala Harris last night on CNN, I will give you, I didn't watch it until like 10 o'clock at night. I watched like the last 10 minutes of it. What I would say is, thankfully, they actually hit the tax question right when I turned it on. To clarify for everybody, if you make more than 400 grand, your tax rate will go up, whether you're a business owner or not. I'm not advocating which way anybody votes on that. I'm just saying she didn't answer the freaking question. So that is the answer to the question. It will go up under her plan, period. If you're a business owner, probably by about 10%. If you're not a business owner, probably by about 2 or 3%. So anyway, with that in mind, Jack, take it away.
So a couple funny things that happened off camera right before we got on. You were talking about, the critique that we get from Gary, and I had just said, I think this angle makes me look fat. And so I trying to, there's nothing I can do about it. That's where my phone holder is. So sorry, everyone, about that. I have been trying to maintain exercise and good. So in case anybody was interested, I am on the road and I tried to park next to an antenna. So I apologize if there's any glitches or, matrix type of, things going on. So two main things that we wanted to talk about today, and we're not going to hold you hostage for an entire hour because there really isn't an hour's worth of stuff to talk about this. So you're going to get a little bit of a reprieve from the Jack and Adam show today. And also because I need to get back on the road and get back to Charlotte. I'm about 2 hours away from there now. The first is, we've been dealing with the Corporate Transparency Act for a while. And I will tell you honestly, from my perspective, that we as attorneys have been trying to put our heads in the sand and say, hopefully someone will come to their senses and say, why do we have to drag the entire business world in the United States into this mess when we're trying really to find bad guys that are doing bad things with money, laundering and those kind of things. And so, it was decided, well, no harm, no foul. A lot of the stuff is already reported to the government. We're just going to put it in a different database. Okay, that's all fine and dandy, maybe. The next thing that our law firm and CPA firms and others had to decide is, are we going to get into the fray of things on behalf of our clients? I will tell you that the thought process initially was, wow, what an awesome way to monetize something that's very simple and can be repetitive and can just be an annuity for a law firm or CPA firm or others that are going to provide this service. As we look into it, and we kind of sort of knew this, but not really, because we were learning as everyone else was, which is, it's not a difficult process. And the reality is that all of you have the information in your possession that you need. And for us to do it, you need to give us possession of that information, like copies of driver's license, copies of passports. You'd have to provide certain information, but it's not difficult information, it's ownership. It gets a little bit difficult or challenging when you stack them up and you have pass-through entities and you have holding companies, et cetera. So there's a little more, it's not that it's super complicated, it's just that there's a further analysis that needs to be done as to who gets reported under certain circumstances. But what ended up happening is that I drafted for the Charlotte office, and the other regional service line leaders in our corporate group did the same, which is, all right, what are we going to do about this on behalf of clients? And we went the route of, let's really encourage our clients to do it themselves, so that it is, and we're not going to monetize this. It really just isn't worth it. Let's guide our clients and let's have them pay for things that are more complex and more important. Not that this isn't important, but it's because it's something you should pay attention to. So what we have done is we said, all right, here is the information that you need. Here is the link that you need to go. And the federal government has walked you through the process, has given you a portal to file this stuff. And so let's encourage others to do that. Now, the reality is that we know that there are different types of people. Some will embrace this and say, yeah, you know what, this is easy, I'll do it. Some, just because it's easy. Some will say, well, I want to save money, so I'm going to do that. Why pay my lawyer or CPA to do it? Others will say, I don't want to touch it because I just don't want to have to deal with it. And so I'm just going to punt it to someone else to do, which is fine. We're happy to do that, but we're encouraging people to do it themselves, because, paying us to do it is not efficient. We're not set up to do it. And so we're going to have to charge you for it, and charge you for giving us information that you have that you can easily do yourself. So the end of that story is, it's easy to do it yourself. We have provided guidance on our website to do that. I am going to publish in the near future a lot of what I'm about to tell you, which is, I'm going to go through terminology. I'm going to go through kind of the process a little bit, and then talk about what the penalties are. There are some exemptions, but I think for most people, it's not going to apply because it deals with revenue and number of employees and everything else. So smaller to medium-sized businesses probably will not reach or meet those exceptions otherwise. So I'll just start from the beginning. And if anybody has any questions as we're going through this, please, feel free to hit us up in the chat or the Q&A. But so basically, this was a law that was enacted in 2021. And again, everyone's crossing their fingers that that when most of us have to do what we have to do, that it will be repealed, that the Supreme Court will step in, that Congress will change, that the White House will change. However, if you remember who was in the White House when this was being pushed through, it was President Trump. The problem is that the Biden administration did stuff with the law that was, I don't think, intended. And so that's why this is a problem. But the reality is I don't know if President Trump gets back in the White House. I don't think that this is going to be repealed. I think it'll be pulled back and toned down potentially. Again, this is a Jack theory, but I don't think it's going to go away. So at this point in the year, all of us are going to have to jump through these hoops. So I'm going to describe what some of these hoops are. And go through some definitions. And like I said, I'm going to publish something very soon. So you can take notes, but if you miss something, don't worry about it. And quite candidly, there are so many people putting out stuff on this that you can find it very readily. And the best source really is the federal government, the FinCEN website that will walk you through all this. So starting out with some key terms. So the first is who has to report. So they define it as a reporting company, and it is kind of what you would think intuitively, which is an entity that's formed in a state through the pertinent Secretary of State's office. So those of us that have North Carolina businesses, we file articles of incorporation or organization with the state of North Carolina. And then you have foreign companies that are authorized to do business in a particular state that kind of go through a similar process. So those would also qualify. The biggest exemption, and I'll go ahead and cover that now, that it is what's called a large operating company exemption. And what that is that, and it's numeric and also based on number of employees, and it's based on location, which is basically anywhere in the United States. So the two big issues or variables are that it is a company that directly employs more than 20 employees on a full-time basis. So it's not on a consolidated or affiliated basis. It is that company under that EIN is paying 20 or more employees. And then you have filed a federal income tax return in the previous year demonstrating more than $5 million in gross receipts or sales in the aggregate. And again, and this can be on a consolidated business if applicable. So there are some rules that do allow you to aggregate certain income. So for example, if it is, you have different divisions that are under different profit and loss centers, essentially general ledgers or their ledgers, et cetera, then you can do certain things. And again, this is just guidance. There are a lot of little tangents kind of thing, but and again, this is an exemption or an exception, so it's not going to apply to many of us. Then you get into, okay, what is being reported? It is the ownership, and they have the defined term is who are the beneficial owners, who are receiving the benefit of being an owner. And they have defined it as any individual who directly or indirectly meets at least one of the following criteria. So not all of them necessarily. A lot of them will meet all of them, but not doesn't have to be. So exercises substantial control. Remember that term, substantial control, because we're going to talk about that in a minute, over the reporting company, or owns or controls at least 25% of the ownership interest of the reporting company. So it is, do you control it? You don't necessarily have to be an owner, or are you an owner and you have control over it? So basically what it's doing is it's capturing those who have influence over the company and the company's operations, but may not actually have ownership interests. So what does substantial control mean? And there are 4 subsets in that definition. So service as a senior officer. Now, the word officer is not capitalized, so it's not defined. Presumably it means someone who is actually appointed as an officer of the company, president, vice president, etc. But you could, without actually being appointed as an officer, act in that capacity. What is unknown at this point is, does this capture all of that? But then you get back into, okay, does the person have control over the entity without being an owner and without being named an officer, capital O, the ones that we typically see like president, vice president. Second prong is authority over the appointment or removal of any senior officer or dormant majority of the board of directors. So even if you're not doing those things, if you have the ability to put your surrogate in those positions to control, you essentially are controlling the company. So they're capturing the deputies of, or the appointees that are really running the business. So that is substantial control. The third prong is direction, determination, or decision of, or substantial influence over important matters of the reporting company. Okay, so now you're getting into a little softer definition of who is controlling the company. And then the catch-all, which, there's usually a catch-all, or any other form of substantial control over the reporting company. So remember, we're talking about the definition of substantial control, and they're using the term to define itself. I mean, that's something that we learned in very early on in grade school and certainly in high school, that not acceptable to use the defined word as part of the definition. So then ownership interest. So now we're getting back to the ownership side of things. What does that mean? It means what you think it means: an instrument, contract, arrangement, understanding. So it doesn't have to be in writing, can be oral, or mechanism used to establish ownership, such as equity, stock, capital, or a profit interest. So it captures all that. We talk about economic interests, profit interests. Now, what it doesn't say is, we talk about phantom equity. I would speculate, again, Jack theory, that the mere fact of having a phantom equity interest, it's not really ownership, it's not really control, it's just a calculation of a bonus in most cases. So I would say that probably not inclusive as demonstrating an ownership interest. And then there is, who is the company applicant? So you have to report who is filing this stuff. And it's either the direct filer of the information or the person overseeing the filing of information. So this is relevant for you guys. It's also relevant for us if we're filing it, because if it is, let's say, your CFO that is in charge of filing it, but has a secretary or assistant or someone else filing it, they could be deemed the company applicant. And so again, we're not talking about the reporting company, we're talking about the company applicant, the individual that is filling this out. So from our perspective, even though it might be my paralegal or my legal assistant who is filing these, they're following my direction and doing it. So I would be a company applicant in addition to my paralegal or my legal assistant. Okay. Now we'll talk about reporting timelines, like who has to do what when. Hopefully, if you have formed an entity after January 1st of this year, 2024, you have already filed your beneficial owner interest report, BOIR. If you haven't, then you need to deal with that. Happy to chat with you offline about what that means. But you have, if let's say you formed an entity April 1st of this year, you had 90 days to file this document. Any entity that was formed prior to January 1, so up and through December 31st of 2023, you have until the end of this year, December 31st, 2024, to file the document. So you have a little bit more time before you're in technical default. And obviously, there's not enough resources in the federal government to come chase everybody on this. So, we talk about penalties, and we'll talk about that in a moment. But So those are the reporting timelines. So again, before January of 24, you have until the end of this year. If you form between January 1 of this year until now, or through the end of this year, you have 90 days. You had 90 days, or you have 90 days, depending on when you file. What is interesting is they haven't said, well, what if you formed today? Do you have the full 90 days, or do you have until the end of the year? I think the interpretation is that you have the full 90 days. However, there really isn't a whole lot of good reason to hesitate and not to file these documents on a timely basis, because you'll be drafting, if you're forming an LLC, you'll be drafting an operating agreement, which will have ownership information in it. So you'll have all that information. May as well just check it off the list and be done with it. And then updates. If there's a change in beneficial ownership, then you need to report it within 30 calendar days of the change. So this is one of the reasons why we would rather not do it, because we are very clear when we are asked to do it, and we do it, that we have no responsibility for updating anything. So let's say that, unbeknownst to us, that a client gives someone 10% equity and maybe recycles a form that we used a couple years ago, which is suitable, and it probably is the same form that we would use, but they didn't tell us. And so they would be required to file an update to that report. So please keep that in mind, that this is a continuing obligation to report any changes in ownership. What do you have to report? So full name, including any trade names or DBA names of the entity, principal place of business, jurisdiction of formation, and your EIN. Sounds pretty simple, right? So, again, encouraging you to go ahead and do it. And it does get a little complicated when you have stacking of entities. And then what does the information related to the beneficial owners? So that's the reporting company. That's the information you have to report to reporting company. Beneficial owners, full name and date of birth, current address, unique identifying number for such individual from an unexpired passport, driver's license, or other specified documents. So if you don't have either of those two, then there's kind of like if you're going to go get a passport and you have to show 2 forms of ID, they have their own list of things that are sufficient to prove who you are to them. And then an image from where you got the unique ID number. So driver's license and passports, which, to be perfectly transparent, I would rather not have that information of you. It's personal information. It's confidential information for the most part. I'd rather not, even though we have one of the most secure, I feel like, databases because of the hoops you have to go through to get into it internally, and then the hoops that others have to go through to get to their own, basically, Dropbox within our system. We use ShareFile, which is Citrix, and Citrix is well known for being very secure and careful about those things. So that is the general gist of it. And so what we were doing again at our firm is that, again, encouraging you guys to do it yourselves. But if you really are insistent, we will do it. We will send to you a request for information. We need to get it on a timely basis. We will process it. We will put it in the correct form. We will send it back to you, and we'll say, is all this correct? And then if you say yes, then we will file it. Again, kind of a simple process. And I'm sorry I keep saying again, but in my mind, I feel like I'm taking your money if we were to do it. But I know there's people who don't care. They just don't want to be bothered with it. So they don't really care how much it costs, and just get it done and let me know that all went well, and let me know what I need to get to. So, and that's fine. And then we have people that are tasked with in our firm as being the experts and go-to people for questions that come up, like the more complicated ones. Well, I have common ownership, but it's not the same ownership. What does that mean? This is a pass-through entity. It's owned by a trust. It's owned, so sometimes there's a little more complexity in the organizational chart that spend a little time with us and we'll guide you through that. So happy to do that. Let's see what else.
Is it okay if I pop in
Yeah,
for a minute, Jack?
of course, of
Um,
course.
a couple things. We had one question on, please spell out the acronym mentioned earlier. That when we talk about the CTA, that's the Corporate Transparency Act, which is the law that was passed that created all this nonsense in the first place. And then BOI stands for Beneficial Ownership Information, which is what you're providing to the government that you have to fill out. And I think Jack's been hitting on it, but I just wanted to make sure we had a point of clarity. A lot of our clients have disregarded entities, meaning like for tax because Jack's mentioned a lot of tax reporting, like 5 million in gross receipts per the last tax term, blah 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 blah. Disregarded entities are included. So if you got you've got if you happen to hypothetically be asking for a friend to have a beach house that you structured for liability purposes in a single member LLC, which would be disregarded because it happens to be owned by you and your spouse for tax purposes, thus no tax returns exist, that crap's still included. And to Jack's, so that's going to catch a lot of people off guard, I think. And then to Jack's point about, hey, there's the whole who has to file. He mentioned trust and stuff like that. People might get confused in that. It's like a trust itself isn't considered an operating company because it's not formed by this. It's not an operating company formed by the state, but a single member LLC owned by your trust, that is a reporting entity because you're ultimately the beneficial owner. So just wanted to get some points of clarity out there as I've been listening to here, Jack.
Yeah, absolutely. Thank you for that. So, and then kind of lastly, penalties. So the, the worst case is, again, I mean, you'd have to screw this up really badly and they really would have to want to come after you. But it is, on the books, it is up to $500 for each day that the violation continues, or criminal penalties, including imprisonment for up to 2 years and or a fine of $10,000. Senior officers of an entity that failed to file a required BOI report may be held accountable for that failure. So similar to what's the term, responsible party, right? And with filings with the IRS. So like a CFO could be deemed a responsible party, I think. I think that's what the concept that they're trying to incorporate here, which is, certain individuals within an entity have a heightened duty to make sure things get done. There are exceptions, and I won't go through all of them, but banks, credit unions, money services, broker dealers, and securities. And a lot of these are because they have to file about themselves in another manner to get licensed or to get certified. So, obviously banks need to go through banking regulations and things like that. Any public accounting firm registered in accordance with Section 102 of the Sarbanes-Oxley Act of 2002.
Woohoo! Yeah, it's like finally my lobby got it right. It's like we got screwed on the Tax Cuts and Jobs Act. Like how is it architects and engineers were exempted from that baby, but we're not? It's like finally one went in our favor.
Yes, I saw that. I was like, woo, congratulations. I was looking for the term law firm in there, but no. So okay. So, if anybody has any questions about that offline, feel free to, or even, while we're talking as it comes up. But I also wanted to talk about, if I can switch gears, Adam, if you're good with that, onto the FTC
Yeah.
non-compete. Okay.
Yeah, absolutely.
So much ado about nothing, essentially, at this point, because there has been 2 courts that have said, yeah, or at least one court, 2 that have said, yeah, not so fast. We need to take another look at this. And the gist of it is that the FTC came out and said that certain non-competes, most non-competes, are going to not be valid anymore. And I had sort of sarcastically, flippantly said, well, that's great. I'm not excited about going to tell my clients that paid a seller a ton of money. And part of that was to bench those individuals. Now, so that is likely going to be an exemption from the lack of enforceability. So then what it comes down to is targeting those individuals that have signed an agreement that says, hey, I want to come work for you, pay me a lot of money. And part of the consideration that the employer is giving is paying the employee that if they leave, they're not going to go compete. In addition to not solicit employees, not solicit customers, not take confidential information. So those things are separate. I'm specifically focusing on those phrases that say, upon termination, you will not work for a competitive business in the restricted territory for the restricted period. And all those things are defined as time, geography, and then who you can't go work for, right? So those three kind of variables. And so there are two sides of it. And then if you read the literature on it, they are the way they categorize it is the Texas court is against the FTC, and then there's a Florida court that sided with the FTC on nearly all arguments. So I'm just going to share some of this. And these are judges, federal judges in both Texas and Florida. Both ruled that the FTC could not enforce its non-compete ban, but they reached that result for different reasons. So essentially, these courts are moving in the same direction. But again, remember that these are district courts, so they have to go up to the appeals court. And then if there's still issues there, then that's where it gets to the Supreme Court if the Supreme Court wants to handle this. And hopefully, it doesn't go that far. But I'm kind of okay with if it stalls out until it gets to there, that's fine, because I have a lot of unhappy people that are saying, is this really happening? If you're on the employer side. On the employee side, it's like, woohoo, I might be able to go compete. And so now I have more leverage over my current employer on certain things that I can go do whatever I want, whenever I want, kind of thing. And again, I'm exaggerating and being a little bit flippant, but I see both sides of it, really. So the Texas court said that the FTC lacked the statutory authority, ruling that the agency generally does not have the power to issue substantive rules regulating unfair methods of competition. FTC is an administrative agency and can only do what Congress has passed and authorizes it to do through statute. And this Texas court said that the FTC went too far. And then they said, and regardless, if they did have the authority, they went too far. And then there's this doctrine called that is arbitrary and capricious. I think that's what they used. Yes, arbitrary and capricious. The court was not impressed what it called the agency's unreasonable, broad, one-size-fits-all approach that did not target specific harmful non-competes, and concluded the FTC failed to sufficiently address less drastic alternatives. So basically, kind of like my comment that I said at the beginning of this in relation to the CTA, that let's just throw this out there and make everybody comply with it, no matter what their circumstances are. They are saying that the FTC is trying to do that here, and that it's not going to pass. So Florida court, as I said, sided with the FTC on all of its arguments. The Florida judge concluded the FTC has statutory authority, but the Florida judge prevented the FTC from enforcing the ban based on the issue that the Texas judge did not reach, which is the major questions doctrine. Okay, so this is a doctrine under federal law that the FTC had to show that it had clear and congressional authorization to issue the ban, since the FTC's rule was extraordinary in its economic and political significance, which is interesting because they threw the word political in there, which I would think that a federal court would not do necessarily. They would focus on the economic impact. So, the cynic in me wonders if the judge did that on purpose so that it would go up to the appeals court, and and the argument would be is, okay, the judge is looking into the political effects of this rather than economic effects of it. And the Federal Trade Commission deals with economic financial issues. So then we can talk about what has to be proven on appeal. And I found this really cool matrix, and it's the argument, it's the Texas ruling, Florida ruling, and then the basis for affirming the result on appeal. And so I'm just going to go through the various arguments. The FTC lacks statutory authority to regulate unfair methods of competition through substantive rulemaking, again, reserved to Congress, is the argument. Even if it had the statutory authority, the rule is unlawful because it exceeds that authority. The rule is unlawfully retroactive. Again, well, I don't think I mentioned it this time. You as an employee would have to go to your employee and say, and you would have to go to the employee. You can't remain silent and say, yeah, that non-compete that's in your agreement, never mind. And so that's why my employer clients are not happy with this, because what they paid an employee in theory and in reality is derivative of kind of what the restrictions are. And if you knew that your employee could violate the non-compete or wasn't in there, might you pay that employee as much? And there's all kinds of psychology behind that. Well, yes, you would, because you're really paying them for loyalty. You're paying them to be there. You're not paying them to not be elsewhere. So I've heard that argument. The rule is unconstitutional because it violates the non-delegation doctrine, which again is that they're taking on power they're not supposed to. Unconstitutional because it violates the Commerce Clause directly from the Constitution, which reserves that right to Congress. Unlawful because the FTC is unconstitutionally insulated from the president. Don't know what that means. It's in the chart. I can speculate what it means, but it's really not one of the core arguments. We talked about the major questions doctrine, and then, okay. The proper remedy is if it's going to have a national impact, then there needs to be more thoughtfulness put into it. And that's the kind of the secular way of saying that, okay, it's the proper remedy is vacatur with nationwide effect. So that's essentially what that means. And then I was, had questions as to, okay, what should employers do next on this, or how should we prepare for this in either way? And so the suggestion is that you review, what you got, which is who is under non-competes, how old are those non-competes, and kind of do an inventory of what agreements have them, because over the course of time you use kind of the same core document, but it may not be applicable. The other danger in using a form document is that even though it may say that the applicable law is North Carolina, it may be for an employee in another state. And then you have conflicts of laws, choice of laws, applicable laws that are determined sometimes by the court in the other jurisdiction. And so you need to be mindful of that. So as you're going through your audit, what is the court of jurisdiction stated, and then where is this employee located if you have employees outside of your home state? And the other thing too is that sometimes the employees' roles will change over the course of time, and it may be that their geography is more restricted, or it is a geography that is expanded, or it's changed. And so the way that the non-compete is put together may not be valid any longer because of the position. So for example, if you have someone, or even the type of position, you had someone that was in sales or marketing, and now they're in finance, and the non-compete reads, okay, anything related to the business, and they haven't been doing marketing for 5 years, and then they go take a marketing job with a competitor. Is that still valid? So questions like that come up. Again, auditing the non-competes, if and be precise with the language that's in them. So if the doctrine of reasonable reliance and of a legitimate business purpose in the restriction come into play, what that means is a fancy way of saying that, okay, if you don't do business in California and you have a restriction that says anywhere in the United States, and your employee goes from North Carolina to California and works for a competitor that only has influence on the West Coast, and you're just upset and you want to enforce this, it's going to be difficult to enforce it, even though the words of the document say entire United States. So you need, again, reviewing those things. I mean, this is, to me, if it doesn't do anything else, it kind of is a wake-up call to all of us employers to look at non-competes, what we have, what is in our legacy documents, what is in our current documents, to make sure that they are enforceable currently, because I really don't think that this is going to fly. So that's kind of the gist of that. I know said we were going to not take the entire time. So those are really kind of the two big core things that I wanted to chat about today.
Yeah, that's awesome, Jack. We'll hit maybe into the overtime and minimum wage rules going into effect in the next webinar. But that was good stuff. I mean, as business owners, we're 1 for 2. Sounds like. And Andrew Tucker posted in the chat, thanks for that. It's like, I've heard that the beneficial ownership information stuff is pretty quick to report. Andrew Tucker managed to get it done in the course of the webinar. So that is true. I guess we've just had it proven that it is less than 30 minutes to get it done. So that's great stuff. When I say great stuff, that's great. That's great stuff. So
Good information, but not, I'm sorry that I have to report you got another pain in the ass to deal with in your business. But of all the things that I could have said, okay, now you have to do. I mean, the FTC, the non-compete obviously would be really bad.
yeah.
This is mild.
It is, but I got to tell you, unrelated, but another dumb thing that nobody's ever heard of that I'm dealing with on another client is that if you have a substantial cash deposit, going back to anti-money laundering, which was one of the genesis of this call is, or this law is that if you have a substantial cash deposit, you're supposed to claim it on a form with the IRS. So banks got to report it anyway and run through all your AML due diligence, but you're supposed to voluntarily also produce a form. Otherwise, you can be subject to criminal prosecution, and it's like, I've had a client that's now who had some cash deposits that didn't report them. And I'll loan, when I say I'll loan it, it's not like I got a call and got consulted in the first place, but at the same time, when I was speaking with the investigators about it, they seemed incredulous when my response was, I got to be honest, until I saw this, I've never actually even heard of this form. So you clearly have not communicated very well that this was a requirement. And it's like the government was incredulous. I'm like, I talked to a lot of my buddies in the business. Nobody else has heard of this crap either. So yet at the same time, it's like there was no like nice, let's play tiddlywinks with each other thing, about this. So I think this is one of those cases where on the BOI reporting, the punishment does not fit the crime. The punishment is ridiculous, relative to the forgot to fill out the form.
Yeah, and I think the reality is it's what we've talked about before, which is resources of the federal government. I mean, are they really going to come after? I think that, they'll have this information and then they may utilize it to kind of kick the tires. Like if they get some anonymous tip I mean, the other thing too is like, okay, well, disgruntled employee using this and saying, hey, they reported on their report this, and it may not be quite right, or maybe you should look into it. So, I want to believe the best in people, but I also know that people get emotional and they do things, and so I'm not suggesting this is going to be weaponized in that fashion, but I think that um, it's the penalties are on paper severe, but I just don't think that there is any realistic way for the federal government to enforce this and enforce everything else. I mean, they're still screwing around with all the loans issues and loan defaults, and there's only so much you can do as far as enforcement goes, and they're really going to focus on the really bad actors. So they're looking for let's say that which will never happen, they clear out all of the low hanging fruit of the bad people, and they eventually get to ordinary people like you and me. And let's say there is a violation, they're going to say, okay, fix it. Maybe pay a penalty. Probably not. I mean, they just don't want to mess with that unless they need some money in the federal government, which they always do, but they're not going to do that. So again, I just told you 60 seconds of total jack theory, and I could be totally wrong.
Yeah. All right. Cool. Awesome. Well, thank you very much, guys. We appreciate it. Gary will be back to keep Jack and I out of daycare next week. So we appreciate you guys being on. In the meantime, if you got any questions you want to see us answer during the course of the week, just shoot them over to us and we'll make sure we get them addressed on next week's webinar. So thank you very much, guys.
Thank you, guys. Thank you,
All
Adam.
right. Thank you.